Well, good evening, everyone, and welcome back to AJ103 Criminal Evidence Online. Tonight's lecture is going to be on Chapter 3, and we're going to be talking about the adjudication process. Now, a couple of reminders. Don't forget about the key terms that are located at the beginning of your chapter, and also the discussion questions at the end of the chapter. And with that being said, let's jump right into our featured case for the night. In 2009, Dr. Conrad Murray was charged with manslaughter in the death of Michael Jackson. Now, the prosecution called numerous witnesses to show Dr. Murray violated medical procedure in administering the sedative propofol to Mr. Jackson. Now, the defense called 16 witnesses excuse me, of their own, but Dr. Murray declined to testify. And this is always kind of interesting. So as we begin to talk about the process, this adjudication process, we're going to kind of go into some questions here, but also we're going to ask ourselves, we're going to spend a couple of seconds thinking about why would somebody not testify? And that's kind of interesting. You call all these witnesses, but yet you decide that you don't want to testify. So when we apply the law to the Jackson case, almost everything done to Mr. Jackson was voluntary. So how can Murray be guilty of an offense if he was following Mr. Jackson's orders? And do you think that Jackson's consent mitigates the crime, meaning kind of makes it less severe because he gave the consent? Or do you think that a doctor, no matter what, should be held to a higher standard? And if you want to look at a little video on that, I have a YouTube video on a newscast of the actual sentencing portion that occurred in this case. But there are many strategies that we'll talk about later on in future chapters that will address this issue of, testimony and whether or not your client or the defendant actually should testify. And just kind of think about that, and we'll get into it. And if you want to know what a case filing actually looks like, because some people don't understand what a felony complaint looks like, if you will. Well, here's a photograph of the actual complaint in this particular case. And we won't spend a lot of time, but you can see Superior Court of the State for Los Angeles, people of the state of California, and the defendant is here, Conrad Murray. And it talks about, it'll tell what kind it is. Here's the case number, and it's a felony complaint, and here's the date, and the count is here. So here's what he was being charged with. On or about June 25th, 2009, in the county of Los Angeles, the crime of involuntary manslaughter in violation of Penal Code Section 192B, a felony, was committed by Conrad Murray, who did unlawfully and without malice kill Michael Joseph Jackson, a human being, in the commission of an unlawful act not amounting to a felony, and in the commission of a lawful act which might have produced death in an unlawful manner. And I know that sounds super confusing because we haven't really gone over the crime types. And typically in this class we may not, but I'm going to help you a little bit as we go through this. And what I'm going to help you with is by showing you a chart. So if you look at that complaint, this defines homicide. And this isn't a class on criminal law, but I wanted you to see that homicide is the big umbrella. And under homicide, you have murder, which can be, the unlawful murder, and it can be a felony, it can be first degree or second degree, and then other death-related areas. So you can have justifiable homicide and excusable homicide, and here are the contents, if you will, or the elements. And then here you have unlawful and voluntary and involuntary. And this section right here is what that gentleman was charged with. Without malice, and malice means, well, there's two types, express or implied, and the definition is down here. So again, not a lot of time, but I wanted you to see that, and we'll kind of move through and get into our learning objectives. So what are we going to learn in this chapter? Well, we're going to list what evidence the prosecutor considers when they're going to file charges. And we're going to identify evidence used for grand juries and preliminary hearings, and what is a preliminary hearing, and we'll talk about that. And we'll explain discovery and suppression, those two terms. And we'll look at the order of a trial, what comes first. We'll explain how juries are selected and how they function, and we'll understand how appeals work and how evidence is used perhaps after trial. So in order to adequately prepare for each court appearance, it's necessary to understand what evidence will be needed. And it must be remembered that preparation of a case begins with the officer's initial observations in the case, not when the prosecutor is doing the final preparation to take this case to court. For example, if an officer stops a car based on reasonable suspicion, the officer should make notes on all the facts that were used to establish that reasonable suspicion. And if an arrest is made, the officer needs to record all the facts used to establish probable cause for that arrest. So you can see how it's starting to kind of take formation, if you will. So that whole starting of a case is really important as we begin to move forward. And there's three options of starting a criminal case. It's the police investigation and arrest. It's the private party or citizen's arrest. Or it might be the indictment by a grand jury. Now, the standard for an arrest, and we'll talk more about this later on, but we should already know this by now, is what we call probable cause. In order to arrest somebody or search them even, or to get a search warrant issued or an arrest warrant for someone, that particular standard is the standard of probable cause. Now, the standard for conviction is a little bit higher, and that is to show guilt beyond a reasonable doubt. And then, of course, we'll kind of move into the criminal complaint. So what is the criminal complaint? And how does that really kind of come into play here? Well, criminal cases come to court from three main sources, kind of as we've just gone over. The police, private persons, and the grand jury. And some states allow police officers to bring misdemeanor cases directly to court, and others have the prosecutor's office handle the filing of all criminal court documents for police and private persons. And the grand jury procedure is somewhat different, and we'll talk about that a little bit later in the chapter. Now, the prosecutor decides which cases should be filed and what crimes will be charged. And in order to do that, he or she needs to know the facts of the case and really what evidence is available. And police reports are frequently given to the prosecutor or the officers interviewed in some locales. Investigators assigned to the prosecutor's office may be assigned to the case. And although the Fourth Amendment establishes probable cause as the standard for the arrest, the prosecutor may want stronger proof before they actually file the case, because a much higher standard or level of proof is needed in order to convict. So think about what I said. So the prosecutor decides what cases are going to be filed, and they get their information from the three options that we talked about. And in looking at what cases to be filed, the prosecutor is going to look at all of the evidence that's presented. And while the Fourth Amendment, we know, establishes that level of probable cause, which is the standard for an arrest, the prosecutor might want something more or at a higher level in order to initiate the filing of the case. And hopefully that kind of makes sense. So the following things I'm going to talk about are those things that the prosecutor looks for in order to file cases. So it could be, how strong is the case against the suspect? Or did the police conduct their investigation thoroughly? Or based on the facts in the police report, was a crime really committed? And were the suspect's constitutional rights violated? And how many witnesses were there, and are they credible? Now, the prosecutor is ethically bound not to file criminal charges against an innocent person. And additionally, there are cases where the suspect is believed to be guilty, but the likelihood of obtaining a conviction is low. And these are just, an example would be, let's say, the sexual molestation of a 3-year-old, where there is no physical evidence, and the child would be easily confused during cross-examination with an attorney. And since most prosecutors are kind of overworked, cases that don't appear to be winnable, if you will, and I didn't say this had to be fair, I'm just giving you the facts, may not get filed. So the initial document is going to be called what's next that we're looking at. It's the criminal complaint. And this is the initial document that states the criminal charges, kind of like the document that I showed you on the Michael Jackson case. That was a criminal complaint. And the criminal complaint must state the facts for each charge. And this includes a description of what crime was committed, kind of like in the document I showed you, where it occurred and when. And the description of the crime must cover every element in the definition of that crime. And this is frequently done by using the wording in the penal code. So the exact wording out of the code, so that way it covers all of the elements. And at minimum, the location where the crime occurred must show the event occurred within the court's geographic jurisdiction. So we talked about that in a previous chapter. Where possible, the exact address is used. And the date is needed to satisfy the statute of limitations. And we talked about that in a previous chapter. So now you've heard a little bit about the criminal complaint and what that actually entails. And again, if I back up a little bit far, but here's the criminal complaint. And it contains those elements that we basically just talked about. So that's an example for you to kind of look at if you're looking for an example. And here's another example of a criminal complaint. Now, ironically, I used the one when Michael Jackson was actually being charged with child molestation. So the first complaint we saw was where his doctor allegedly had overdosed him, etc. And the second one here that we're looking at now is the actual criminal complaint filed in Santa Barbara against Mr. Jackson. So you can see that it lists the counts, which are the separate charges, and it'll go through everything. It'll have the date, the code section, where it was committed, a description of the section, etc., in order to fulfill all of those elements. So, kind of in review before we move on, the following things are considered by the prosecutor when they file a case. It's how strong is the case, and did we in law enforcement conduct our investigation thoroughly, and based on the facts in the report, was a crime committed, and are the elements there, and were the suspect's rights violated in any way, and how many witnesses are there, and are they credible? So, although the Fourth Amendment established probable cause as the standard for the arrest, remember, the prosecutor might want some stronger evidence or proof before filing the case. And finally, we did, kind of as a repeat, the prosecutor is ethically bound not to file criminal charges against an innocent person. So how do we apply this law? Some questions to think about relating to profiling. And these are just questions that I come up with. So what about the use of profiles to identify suspects? When does a profile cross the line and become stereotyping? And are the wealthy and poor suspects treated differently? Think about that as we continue to kind of move through the process of adjudication in this particular chapter. So the first thing that's going to happen now, after the prosecutor decides what charges to file, the complaint's going to be typed up and taken to the court clerk, and delivering to the complaint to the clerk is called filing the complaint. And after it's received, the clerk's office will handle the paperwork, including the scheduling of the case for future court dates. And once the complaint has been filed, the suspect is legally known as a defendant once that complaint is in. So the next step would be the arraignment. And it might go a little bit different order depending upon what state you're in, but we're going to try to keep this as general as possible. The name of the defendant's first court appearance varies depending upon the state, and again, it may be called an arraignment, it may be called first appearance, and in some cases it may be called even the preliminary hearing, but it won't be in the case that we're talking about. And then in this text, we're going to refer to this first hearing as the arraignment. And it's a brief court hearing for the following purposes. So it has multiple purposes. And it could be to inform the defendant of what charges have been filed, to make sure the defendant has an attorney, to set bail, to enter a plea, or to set the next court appearance. And these are all things that could take place at the arraignment. Now, if the defendant does not have an attorney, the judge will try to determine if the defendant qualifies for a free court-appointed lawyer, or if the defendant wishes to proceed without a lawyer, called self-representation. Now, appointing an attorney is a high priority because the defendant can't enter a plea without counsel or a formal waiver of that right. And witnesses are not called, nor is evidence evaluated at the arraignment. So we're pretty much kind of dealing with these 5 issues right here, and maybe not exactly, again, from state to state. The defendant is going to be asked to enter a plea, and guilty and not guilty are the most common pleas. Now, if a defendant enters a plea of what we call nolo contendere, which means no contest, the criminal courts will treat that case the same as if a guilty plea was entered, but civil courts might treat it a little bit differently. But it's similar to guilty with less use in the future against the defendant. And the arraignment can also serve as what we call a probable cause hearing. And sometimes they're this in the same time, and sometimes they are not. They can be separate. So just kind of keep that in mind. And to qualify, the arraignment must be held within 48 hours of arrest, and the judge must review sworn statements to determine if there is in fact probable cause for the arrest. And a probable cause hearing is not required if a judge previously issued an arrest warrant for the defendant, or the defendant will not be held in custody pending trial. So you don't need that probable cause hearing. But if the arraignment is not held within 48 hours, a judge must review sworn statements stating the facts of the case and determine if there was probable cause. And neither the defendant nor the defense attorney needs to be present when the judge makes their decision. So a very simplistic kind of way for me to explain this. If somebody gets arrested, and let's say it's at the department that I worked for in the Inland Empire, and they take them over to the, they arrest them and they take them over to the West Valley Detention Center. They have actually a court officer over there, and now we have 48 hours to get our statement of probable cause, if you will, because the court officer or a judge is going to review that probable cause to see if there's enough cause to hold the person in jail. And if there is, and they can't get out on bail, chances are they'll hold them in jail until their first hearing, or maybe even their second hearing. And their first hearing could be an arraignment or a prelim. It just kind of depends again, okay? If they bail out, there's really no reason for that probable cause hearing. So hopefully that kind of makes sense. But it can be combined with the arraignment. It's mandatory within 48 hours. That's all you need to know. And it does establish if there is enough probable cause or enough evidence to go to trial on the charges. So after the arraignment is typically what we call the preliminary hearing, and it's kind of like a mini trial, and it's required in most states if an arrest was not based on a grand jury indictment. And again, the preliminary hearing is like a little mini trial without a jury. The defendant is represented by their attorney, and the prosecutor represents the state. And the purpose of this hearing is to have the judge hear the case, the basic premise of the case, and decide if there is enough evidence to prove that a crime was committed by the defendant. And it kind of determines if a crime occurred. So again, the preliminary hearing is a mini trial without a jury. And the purpose of this hearing is to have the judge hear the case and decide if there's enough evidence to first prove that a crime was committed by the defendant, and require the defendant to face trial on the charge. So it's kind of self-explanatory, if you will. It determines if the defendant in custody should stand trial based on like that very low level, that prima facie case, just enough evidence on its face. And the rules for admitting evidence in these preliminary hearings are very relaxed. And if sufficient evidence is found, the defendant is actually what they call bound over or held over, meaning they're held over for trial, or they're held to answer, which means the prosecution is authorized to go forward to trial on the charges. And we talked about the prima facie case. Now, if the judge decides that there's not enough evidence, then of course the case can go the other way, and the person can be released, or the prosecutor may even drop the charges. So the prosecution's evidence at these preliminary hearings must establish that prima facie case, meaning that it's more than likely than not that the defendant committed the crime charged. And the judge does rely on what each witness says and whether or not he or she believes the witness was telling the truth. And if there's more than one charge filed, the judge has to make a decision on each felony charge. And assuming sufficient evidence was presented at the end of the hearing, the judge will make the decision and basically hold the defendant to answer or bind them over, or they're bound over, meaning that they're going to hold them over for trial. And again, if the judge does not hold the defendant to answer on the felony charges, the information will only contain the felonies authorized by the judge, and the prosecutor, of course, can drop charges from the case at this time as well. So when this is done, the prosecution files basically what they call an information sheet. And these are the details of the charges. Well, what about this grand jury thing? Because it's kind of weird. And maybe you've heard of the term grand jury before, and maybe you haven't. But in criminal cases, the grand jury takes testimony, reviews evidence, and decides if the suspect should be charged with the crime. It cannot convict. Grand juries also have duties unrelated to criminal cases, primarily reporting on the efficiency and honesty of, let's say, local governments. And the grand jury is comprised of citizens, not prosecutors. And each state is free to establish its own rules on the size of the grand jury and how those grand jurors are selected, provided there is no racial or gender discrimination. And states also set the size of the grand jury and decide how many grand juries can be impaneled simultaneously. Now, the grand jury has the authority to call witnesses and ask questions under oath regarding the crime. And these proceedings are held in secret. The suspect doesn't have the right or doesn't have to be informed that an investigation is underway, nor does he or she have the right to be at the grand jury proceeding unless they're called to testify. There's no right to have an attorney present in the grand jury room when a suspect testifies, nor is there a right to have the defense attorney present when other witnesses testify. The defense does not have a constitutional right to call witnesses or cross-examine witnesses called by the prosecutor. So the state law establishes the voting procedures for grand juries. And basically, unanimous voting is not constitutionally required. So another word would be unanimity. It's not constitutionally required. And some states allow all charges to go to trial if the grand jury is convinced that any one of the alleged felonies was committed by the suspect. And at the conclusion of the hearing, the grand jury returns a document that's called an indictment. So if the grand jury decides the suspect should be charged, the document, or a document usually called a true bill of indictment, is going to be filed with the court clerk. And the defendant is considered indicted. Now, on the other hand, if the grand jury decides there's insufficient evidence to charge the person, it returns what we call a no bill of indictment, which prevents the prosecutor from filing charges in the future. So the interesting part here, when you look at the Fifth Amendment, and this is how laws, our process has evolved, it says no person shall be held to answer for capital or otherwise infamous crime unless on presentment or indictment of a grand jury. And then there's a couple of exceptions. But this became very cumbersome because not every prosecutor's office uses a grand jury. So the laws were kind of formed where if you have a prosecution process in place, which would be through, say, the district attorney's office or what have you, excuse me, you can file the cases through that office directly, and you don't necessarily have to utilize the grand jury. So I just wanted to point that out because a lot of prosecuting offices don't use the grand jury. And here is kind of a picture, and it's hard to see, but you can see what an indictment looks like. And when you look at, this is one where the individuals, the government officials in the city of Bell were basically being overpaid, and there was a lot of issues surrounding retirement and stacking of money and all kinds of things surrounding the way they were paid and etc. So you can look here. This is actually a grand jury indictment, if you will. And it's the same thing, okay, with the count one, but when you go down here, a true bill, you can see it right here. So this means that they did believe the prosecutor's information and witnesses, and therefore they issued this indictment against these two individuals for these charges that are right here. So I'm hoping that that kind of helps you make sense. Now, finally, in the case of Hurtado versus California, the Supreme Court gave states the option. Remember I talked about where sometimes, although that Fifth Amendment said, hey, dude, you need to use a grand jury. Remember this one? Well, there's a case that came about, and this is it, Hurtado versus California, where the Supreme Court gave the states the option of using the grand jury or developing some other legal screening system through the district attorney's office, if you will. And here's the case link that goes with it if you want to look more. And typically now you'll have a lot of states, they don't use the grand jury for a lot of criminal things. Even though they can, but they go through the district attorney's office. So that's the case that kind of set the stage for that. And as part of all this process, so we've talked about the arraignment and preliminary hearing and the criminal complaint, and we know a little bit about grand juries now and even some of the Fifth Amendment. Well, as you're going through this process, there could be something called a suppression hearing. And the purpose of a suppression hearing is to allow a judge to decide if evidence can be used at trial. And most states require the defense to make the suppression motions prior to the trial if the defense knows of any grounds to object to evidence due to illegal search and seizure or improper procedures used to obtain confessions. Now, some states also allow other evidentiary issues to be decided at the suppression hearing, but typically it's going to be whether there's going to be an objection to evidence due to illegal search and seizure or improper procedures used to obtain confessions. And the reason they do these suppression hearings, before the trial is because they want to be able to make the trial itself more smooth, meaning that everybody knows the ground rules, both sides going in, and if they can argue the issues of evidence before they go to trial, they can get this done, and then they don't have to waste all that time in front of the jury or away from the jury trying to deal with whether something was deemed legal or not legal. And that probably makes sense on an efficiency standpoint. Now, the normal rules of evidence apply at this particular hearing, and evidence can be or most evidence is suppressed because of a constitutional violation. Now, the defense may schedule the suppression hearing at any time before the trial, unless local court rules mandate otherwise. And in practice, suppression hearings are normally held after the preliminary hearing in felony cases. And there are so after the preliminary hearing, but before the trial. So let me make sure I slide that in there. And again, there are two main reasons for this. Okay, if the case is dismissed at the preliminary hearing, no suppression hearing will be necessary, and testimony given at the preliminary hearing may alert the defense to a need for a suppression hearing. So at the preliminary hearing, the defense can pick up on some things that might say, you know what, maybe I need a suppression hearing, even though my person might be held to answer, but I'm going to order up this suppression hearing before the trial will start. And on page 63 are some examples of issues heard at suppression hearings. Now, the most evidence, again, is suppressed because of involuntary confessions and illegal searches. Well, along with suppression hearings, before the trial starts, typically, is this thing called discovery. And the idea behind discovery is that each side should have ample warning of what the other side is going to present at trial. Now, it's not like in the movies where the hush falls over the courtroom, the doors open, and some guy charges in with some brand new evidence, and the judge will allow it in. That's not how the court system works. So trust me. And they try to make it fair through this discovery process. And this should make the trial more efficient and promote the process of truth finding. It also reduces the number of times it is necessary to stop the trial so an attorney can prepare to question these surprise witnesses. And the growing practice of pretrial discovery has eliminated most of the dramatic surprises at trial, kind of like the ones I was talking about. And discovery, or the right to know what evidence the other side has, it does vary, again, from state to state. So you're not going to find super consistency here. And there are two areas where the U.S. Supreme Court has, however, required discovery. And here you go. The first is the name of an informant must be disclosed when the true identity of this person is necessary for the defendant's case. And second, the prosecution must disclose any evidence it has that tends to indicate the defendant is not guilty. Well, gee, why would we want to do that? If we have evidence that the person's guilty, why would we give that to the defense and give them the silver bullet that they need to get their client off? Well, that's because the Supreme Court has basically stated that this is what you're going to do, and it's a level of fairness. So the prosecution, again, must disclose any evidence it has that tends to indicate the defendant is not guilty. And this material evidence is often referred to what we call Brady material, because it's based on a case called Brady versus Maryland. And it's the leading Supreme Court case. So the defense may refuse to disclose defendant's testimony under the Fourth Amendment protection. And this process can be formal if ordered by the court, or even informal. So kind of continuing here for a few minutes before we move on and look at this Brady case. In 1970, the Supreme Court ruled that the defendant's privilege against self-incrimination was not violated by discovery rules that required the defendants to notify the prosecution that an alibi defense will be used. Disclose where the defendant claims to have been at the time of the crime was committed, and give the names of the alibi witnesses. So here's an example of the Brady versus Maryland case. And just really quick, Mr. Brady was accused of murder and he was placed on trial. And he admitted being involved but claimed that Mr. Bobbitt committed the murder. Now, Mr. Bobbitt confessed to the police that he had in fact committed the murder. And the police had his signed confession. But Brady was convicted. But on his conviction, it was overturned on appeal. And the rule became the prosecution must turn over all what we call exculpatory evidence to the defense. Because if we already had a signed confession that this guy is the one that did it, but we didn't tell the defense, don't you think that would be a little bit unfair? And I'll let you kind of decide that. But that's the rationale behind the Brady decision. So quickly applying the Brady doctrine, the state often controls almost all the ability to gather, preserve, test, present, and share evidence. But how can we be sure that the prosecution doesn't abuse this power? And most prosecutors are elected. Do they run promising full disclosure or greater penalties for offenders? And how can we deal with the conflicts of interest like this? So again, these are just questions for you to think about. So along with some of the terms that we've looked at, suppression hearing and now discovery and exculpatory evidence and indictment and all these cool phrases, we're going to talk about plea bargaining. And this is something that can kind of seem a little, different. And maybe you don't know what plea bargaining really means or how it can impact the system. But let's kind of talk about it a little bit because it is important. So plea bargaining is the process whereby the prosecution and defense work out an agreement for the defendant to plead guilty to one or more charges without a trial. Now, in return, the prosecutor usually agrees to drop some of the original charges or reduce sentencing demands. And when the agreement is reached before the charges are filed, the process is referred to as charge bargaining. Now, after the charges are filed, it's called plea bargaining. And both of these are now recognized as a legitimate part of the legal system in most jurisdictions. So, examples of plea bargaining include the complaint included 5 counts of burglary, but the defendant was allowed to plead guilty to 2 counts and the remaining 3 were dismissed. Or the original charge was for robbery, but the defendant pled guilty to a lesser charge of theft. And either the prosecutor or the defense attorney may initiate the plea bargaining process, and many factors are considered when we talk about plea bargaining. And one is that, or one that is very important, is the strength or weakness of the evidence in a case. And both sides will consider police reports and testimony given at the preliminary hearing and what is obtained during discovery. And all of this information is put together, and the attorneys will decide whether it's in the best interest of either side to possibly enter into this plea bargain. Now, prior to accepting a plea bargain, the judge must question the defendant in open court to ascertain that he or she truly understands the constitutional rights that are being waived when a plea bargain is entered. So some of those would be the privilege against self-incrimination, or the right to trial by jury, or the right to confront one's accusers. If you take a plea bargain, you're basically giving up those 3 things that I said, those 3 rights. So that's why the judge will do this in open court. And this is sometimes referred to as a Boykin waiver. And many states require the defendant to sign forms designed to explain all of the details of the plea agreement and the sentence, as well as the constitutional rights involved. And they call it a Boykin waiver. So applying the law to plea bargaining, well, you know what? And we know this, almost all cases, 90% plus, they don't go to trial. So should we focus more on rights before trial than a trial? And how long should it take to go to trial? And should it matter if the suspect can't make it or isn't granted bail? Again, just some thoughts to think about as we go through this. So now we're going to talk about the trial, but here is the criminal process as outlined by the city of San Diego. So I wanted to give you kind of a chart you could look at, and you could see what happens from a warrant request or from an arrest where the case is reviewed by the DA, and we're going to decline it, or it's going to go to the grand jury if that's the way that we do things, or the case is going to be issued. And then there's going to be the arraignment. Remember, we talked about that. And if there's a guilty plea, it's going to go here. And if it's a not guilty plea, it keeps going here. And then there's maybe a felony, what they call a felony dispo conference. But if it keeps going, it's going to go to preliminary hearing. Well, we've heard that before. Okay? And it could be dismissed there, or it could continue on. And again, the preliminary hearing, there's going to be some motions and hearings. And there's going to be what they call a readiness conference. And a lot of these things, I'm going through the big pieces. And then there's going to be the trial, and then you're going to get guilty, or you're going to get not guilty, or what have you. So this is just kind of a chart that walks you through. But what about the trial? Well, the trial is the highest profile action in the criminal justice system. And trials in most states follow the format that's in your textbook on page 67. It's jury selection, opening statements, prosecution, defense, rebuttal, jury deliberations, verdict, and sentencing. And we'll walk through some of these, but it's on page 67. And trials, again, in most states follow the format that's on page 67 and include opening statements and prosecution witnesses, defense witnesses, rebuttal witnesses called by either side, closing arguments, jury instructions from the judge, and then jury deliberation and verdict. Well, part of the jury selection is kind of an interesting part. So the Sixth Amendment guarantees the right to trial by a jury of one's peers in criminal cases. And although the U.S. Supreme Court has said this only applies to defendants facing more than 6 months in jail, many states provide jury trials in all criminal cases. Now, historically, the criminal jury was comprised or composed of 12 people. Now, the U.S. Supreme Court has ruled that the Sixth Amendment requires a minimum of 6 jurors in a criminal case, but many states still use 12 or require 12. And the idea of a jury of our peers has been interpreted to mean that the jury must be from a cross-section of the adult, not juvenile, adult population of that judicial district where the trial is held. And the initial phase of the jury selection is conducted by the jury commissioner or someone at the courthouse who handles assembling jurors. And a master list of everyone eligible for jury duty must be compiled, and traditionally voter registration records were used for this purpose. And more recently, the master jury lists have been enlarged in order to cover a greater portion of the population. And some states now combine voter registration and driver's license information. And once in the courtroom, the names are randomly drawn to fill the jury box, and prospective jurors take an oath to answer questions truthfully. And the phrase voir dire is the process of asking questions to determine if somebody is qualified. that is conducted to determine if these people can consider the evidence of the case with open minds. So these are questions that jurors answer to be selected to a jury. And when jury questionnaires are used, a set of written questions are completed by each prospective juror, and the answers are reviewed by the attorneys before voir dire begins. And sometimes they use those questions and sometimes they don't. And although voir dire is traditionally done by attorneys, many states now allow the judge to ask questions in order to save time. So, juries, they can be screened with a preliminary questionnaire, which gives some basic facts about the juror. And they look for some obvious reasons, to disqualify somebody. And on page 69, you can see some different questions. Like, do you know the defendant in this case? And do you know the victim? And you can imagine that if you said yes, it might be hard to convince either one of the attorneys that you might have a preconceived notion on the guilt or innocence of somebody. And that's why they do this. And here's just a little outline of the Sixth Amendment. So the attorneys will ask the judge to dismiss anyone whose answers during their voir dire indicate that he or she will not decide the case solely on the facts introduced at trial and the law as stated in the jury instructions. And this request is called a challenge for cause and may be used as often as believed necessary. And reasons for being excused at this stage include racial bias against the defendant, belief that the police only arrest the guilty, and maybe even exposure to pre-trial publicity to the extent that the prospective juror has already formed a conclusion about the guilt or innocence of somebody. And states do put a number on the amount of challenges that you're going to get, and we should get to that shortly, okay? So we have these challenge for cause, and we have these peremptory challenges, and I'll keep going and we'll get to that. Now, in order to successfully challenge for cause, an attorney must convince the judge that the prospective juror will not base his or her decision on what occurs inside the courtroom. And generalities such as friendship with a police officer or even being a police officer, that's not enough. Now, if a juror is excused, a new name will be drawn. And the new juror will be asked similar questions, and the attorneys will have a chance to challenge him or her. And this process is repeated until there's enough people in the jury box to form a jury. Now, next, though, will come what we call peremptory challenges. And these are used to allow each side to replace jurors who they believe subjectively feel cannot be fair. And there's no reason that needs to be stated for using this peremptory challenge, but a juror may not be excluded solely on the basis of race or gender. The prosecution and defense alternate back and forth in using their peremptory challenges. And if a juror is excused, a new juror will be called, questioned, and possibly challenged. And that's how the system basically works. And if you've ever gone to court, this is what a jury summons looks like. So you can see this is one that I had to appear on when I left law enforcement, because as an officer, I was able to be excused from jury duty. However, as a civilian and former law enforcement officer, I still had to go to jury selection. And this link down here gives you a little bit more insight on that voir dire or jury selection. So now we kind of move on to the trial or the courtroom and controlling access to the jury. So the center of attention in the courtroom is a dais, if you will, on which the judge's desk is located, and the witness chair. And facing the judge in the middle of the courtroom are two tables, one for the prosecution and the other for the defense. Now, the prosecution usually sits at the table closest to the jury box, and there is usually a lectern or a podium for the attorneys to use when addressing the judge or questioning witnesses. And the court's clerk desk is usually located at the side of the judge's platform opposite of the witness box. And if there is a court reporter, a small desk is usually located between the judge's platform and the tables for the attorneys. And the bailiff's desk is frequently to one side of the room. The jury box is typically along one wall perpendicular to the judge and the attorneys, and facing the judge. In the back of the room are seats for spectators. And if you look at page 71, it talks about it's kind of a diagram on where everybody would sit. Now, controlling access to the jury, well, the judge may seek to, or the attorneys may seek to sequester the jury away from possible news about the trial. And of course, we know the courtroom participants. We kind of walked through some of those already. But in a courtroom today, there's quite a bit more technology than what was used before. Kind of in the early days, there would be big, maybe photographs that were blown up and put on poster board and put on an easel or on some type of wall or board so people could see the exhibits and things like that. Well, now there's a lot of digital images can be used, and they still use regular photographs as well, but there's a lot of different technology that's used to make the courtroom a lot more efficient, including accurate records of the trial, the transcription, and then again, photographic digital evidence and different things like that. So a lot of technology that's brought into the courtroom as opposed to many years ago. So now we're going to start the trial, and we're going to have to move through this pretty quick because we're kind of running out of time, and I don't want to leave things out, but I'll walk through it as briefly as possible. So we're going to start with opening statements, and these are given by each side, and it's voluntary for the defense. The prosecutor will open up with a statement. The defense can, but they don't have to. And they explain what they seek to prove. And again, it's not evidence. Only evidence given at trial by witnesses under oath can be considered by the jury. The purpose of this opening statement is to kind of introduce the jury to the case. And two things are usually talked about in that opening statement. It's the facts of the case and the role of the jury in deciding guilt or innocence. And the opening statements are particularly important in long cases because the jurors sometimes need help in fitting the pieces of the puzzle together, especially if the facts aren't going to be presented in, let's say, chronological order. So the next thing that will happen will be the prosecution's case in chief. And the prosecution presents its case first. And during the prosecution's case in chief, the prosecutor must establish every element of the crime charged beyond a reasonable doubt. And each witness will be called to the witness stand, given the oath, and ask these questions, or ask questions. And questions by the attorney who called the witness is called direct examination. And during direct examination, the attorney asks questions and the witnesses answer them, and questions are limited to things that are relevant to the case. Now, questions can also be asked by the defense attorney, which is going to be what we call cross-examination, and we'll get a little bit more into that in a minute. So the prosecution goes first, presents its case first, has witnesses sworn in to prove each element of the offense, and they are asked question. And direct examination of witnesses, typically shouldn't be leading. The prosecutor will ask questions. They try to keep the questions to where they're not leading the witness. So, for example, on direct examination, the prosecutor could ask, "What color shirt was he wearing?" instead of, was his shirt blue? So do you understand now the difference between leading, was his shirt blue? Well, you're kind of leading the person instead of asking what color was his shirt. And to avoid irrelevant facts or evidence, they try to stay away from long, narrated type questions. So the questions are usually brief. And on page 73 will be some examples to that. And while the prosecutor is conducting their direct examination of a witness, the defense may make objections to the questions. Remember that contemporaneous objection rule? That requires that objection to be made immediately after the question is asked. So we kind of already know a little bit about that. And then there's the admissible evidence portion. All evidence is introduced by calling witnesses to the stand. And if any physical evidence, such as a murder weapon or something like that, is to be introduced into evidence, a witness must be called who can tell where the object was found and what happened to it since it was found. And this is called laying the foundation. And once it has been shown that the object is relevant and it has been authenticated, meaning shown that it hasn't been altered or tampered with, it will be given an identification number or a letter. And hopefully you're kind of with me now. So this seeks to exclude or limit opposing counsel to evidence. And again, the judges will rule on admissibility. Sustaining an objection will bar its admission, and overruling an objection will allow evidence in questioning to continue. So we're kind of on the evidence part now, remember? Only admitted via witnesses. And it requires that basis, okay, or that explanation, if you will, to lay the foundation in order to get evidence accepted as evidence. Now, the Sixth Amendment right to confront witnesses has been interpreted to mean that the defendant has the right to be present when the prosecution witness testifies. And reforms intended to ease the trauma of child abuse victims suffered while testifying have had to comply with the Sixth Amendment. And closed-circuit TV sometimes can be used so that these types of witnesses do not have to look at the defendant, but only if there is a clear showing that the physical confrontation would cause severe emotional trauma. So sometimes maybe you've seen people testify via closed-circuit TV, and there are some exceptions, such in child sex crimes cases or abuse cases, but typically the Sixth Amendment says that you do have the right to confront and cross-examine those witnesses against you. But I wanted to make sure that we understood the laying the foundation in order to admit physical evidence. And on page 74, there's some information that talks about laying the foundation. So cross-examination, well, we just talked about that. That's that critical constitutional right that the Sixth Amendment gives. And it's used to point out flaws or inconsistencies or even lies. And again, we kind of gave the example where it's limited if witnesses need some type of special attention. So we could do like video for sex crimes or things like that. And then when it comes to questioning of witnesses, we have something called impeachment and rehabilitation. And impeachment is attacking of a witness based on some problem with his or her testimony, or the witness himself or herself. And rehabilitation is one opposing side seeks to explain the problems or issue under which that particular witness was impeached. So the cross-examination, under cross-examination, the defense attorney tries to trip up the witnesses or even the police officer and attack your credibility or how you obtained evidence, or look for inconsistencies in the hopes to impeach this particular person. And if they're sort of successful in doing that, there's this thing called rehabilitation where the prosecutor can basically get back with that particular person on the stand and ask them questions to try to explain why the mistakes were made. So hopefully that kind of makes sense as well. Well, what about the defense? Well, next would be the defense's case in chief after the prosecution goes. And a defendant doesn't have to offer any evidence. The presumption of innocence requires the prosecution to prove all of those elements of the crime. And usually, however, the defense will call witnesses and present evidence, because if they don't, even though we're not supposed to look at it this way, if the defense has no evidence, people might assume that they're guilty because they don't have any evidence. And they might actually even assume that the person is guilty because they don't testify. Remember the Fifth Amendment? You don't have to self-incriminate yourself. So you can call a bunch of witnesses, but you don't have to testify yourself. And we've seen a couple of cases on that in this chapter, and I believe the chapter before this. And defense, they'll also call character evidence. And the defendant may seek to show his good character. But if they do this, then they're going to open the door to much more damning evidence, meaning cross-examination by the prosecutor. So anyone the defense calls as a witness, the prosecution gets a chance at cross-examination. And the same with the prosecution. The defense gets a chance at cross-examination. And again, that may be why sometimes defendants don't testify. So, along with this would be something that's called rebuttal or rejoinder. And rebuttal is when the prosecution calls a witness after the defense's case. And it seeks to rebut testimony offered by the defendant or a defendant witness about an issue not raised by the prosecution. And a rejoinder is when the defense calls a witness after rebuttal to reject the witness or evidence that's used by the prosecution. So you can see how this kind of fits together for both the prosecution and the defense. And then finally, we have closing arguments where each party offers their explanation of the trial. And then jury instructions, and this is done by the judge. The judge explains the law to the jury. And often from a prepared copy agreed to by each side. So all the information is going to be seen by both attorneys for the most part and agreed upon by both attorneys. And then we have jury deliberation, which is done in private. And it's where they review evidence and they reach a verdict, hopefully. And it can be unanimous or by majority in some states. Now, California, you have to have all 12 jurors, so it has to be unanimous. In some other states, it may not be the same way. And again, after trial, you could end up with no verdict or what they call a hung jury. And in this case, you can elect, the prosecutor can, to retry the case and not violate that double jeopardy rule under the Fifth Amendment. And the verdict is called, that's how the jury voted on each charge. And part of the verdict, after whether it's guilty or not, you're allowed to do what they call poll the jury, which means that you can have the jury confirm their vote out loud to make sure that they're voting the way that, or the information that you're getting as the attorney or the prosecutor or the defense attorney, either one, make sure that they're voting the way that they initially did by ballot or what have you. And sentencing, if guilty, often delay to allow the judge to consider the verdict. They may order up a probation report on the defendant, and sometimes the jury sets the penalty as in capital cases. And then post-conviction, well, that includes things like appeals that are filed after the guilty verdict. And of course, if it's not guilty, then the person is acquitted. So I know I finished up that last portion pretty quick, but I wanted to make sure I was able to get through it, and we're just over the 60-minute mark. So if you have any questions, please feel free to post them on the discussion board. If you don't want to put them there, you can email me, And if that's going to be it, and that is it, until next